Thank you. May it please the court, my name is Stuart Graham, counsel for the defendant Agapito Lau. This is Mr. Lau's appeal from his conviction for first-degree murder. I'll assume the court's familiar with the facts. Excuse my voice.
Would you like some water?
And I have something. Proceed to the argument. First issue I wish to address involves the victim's statements regarding the defendant's motive for acting. Mr. Lau contends this was an inadmissible opinion regarding the defendant's state of mind. Yasina Lau, the victim's daughter, testified to a conversation that she had with her mother the evening before the incident here. Her mother had been out with the defendant, came back, and was quite upset and excited.
Now, that's when she said, when the mother reported that he had tried to run her over.
That's correct. It's that conversation, and that conversation is admitted as an excited or spontaneous utterance. We take no exception to the statement, he tried to run me over with a car. That clearly was an excited utterance. However, during that same testimony, the prosecutor asked the witness whether her mother told her what caused the defendant to try to run her over. She answered, they had gone out that night, I was telling you about the divorce, and that my boyfriend was moving in with me tomorrow. That was the answer to the question.
If the question had been, did she say anything else while she was in this excited state? Or did she say anything else right after she told you that, and the answer had been exactly what it was? Would there be a problem?
Had there been a different question that was a proper question, and this answer came in, there would not have been an objection.
So it's really the question that's the problem.
It's the question's the problem. It's asking her to describe what the defendant's motive was, why he acted this way, what his state of mind was. That is inadmissible.
Are you saying that it was testimonial in the Crawford sense?
No. I'm saying it just violates the state's rules of evidence.
But I mean, the problem, of course, is here there was no objection. I mean,
That's correct.
So the way it probably should have worked is there should have been an objection saying the question invites a statement as to the state of mind of the defendant, and how can she know that? Judge sustains it. Question rephrased.
That's correct.
Same thing comes in, and the jury understands the very same thing, because she just said he tried to run me over, and then she would say she had just told him that night that she had filed the divorce papers and had moved in with her boyfriend. So, I mean, wouldn't the jury understand that that was why he tried to do it, and doesn't that make this error harmless?
Whether the jury would have understood that had the question been proper is a different question than the one that's presented with the court. The question presented here is whether a witness can tell the jury why this defendant...
And I agree that you're right about that this question should have been objected to and sustained. The question is whether it constitutes a miscarriage of justice for having come in this way. And my question to you is, if a proper objection would have triggered the question being reframed, and if this information could have been properly obtained from the witness as an excited utterance, why should we say that it's fundamentally unfair to your client?
Because I think we have to deal with what actually happened rather than what speculatively could have happened had things been different. We're presented with the case and with the evidence as it came in this way, with the witness drawing the inference, the witness describing the state of mind, rather than allowing the jury to draw the inference. There is no way to say for sure that the jury would have drawn the same inference. With all of the other testimony that came in, they may have concluded he didn't do it. This is the reason this creates substantial likelihood of a miscarriage of justice. It's because here is in the first trial. The Commonwealth's case was wholly circumstantial. And the court will remember this was a retrial following the grant of a motion for new trial by this court. In the first trial, the court held the evidence was sufficient, quote, in significant part on evidence that the defendant had a motive to kill his estranged wife. There was no forensic evidence linking the defendant to the scene. two witnesses, the Commonwealth witnesses, placed the van like the defendant's in front of the house, when at the same time the Commonwealth proved the defendant was across town with his van at the Home Depot. Mr. Santiago said he saw the defendant.
Sorry, I thought he admitted that he was at a McDonald's about 7 minutes away, that he had gone from the Home Depot to McDonald's, and that the McDonald's was near Chelsea, was in East Boston.
The two witnesses placed the van between 8:30 and 8:45.
Okay, no, I know that if those witnesses, if that's the van, and if those witnesses are correct, that he probably would have been acquitted. But assuming the jury was not persuaded that their time was correct or that that was the white van, if he said he went, I gather, from the Home Depot in South Bay traveled to a McDonald's in East Boston.
At around 9:15, right?
That's correct. My point was at the time he was at the time the van was seen, he was at the Home Depot, was my point.
Right, I understand that.
After that, when he left the Home Depot, and we don't know how long that took, he then went to a McDonald's where he both made a phone call and said he ate breakfast. That comes into part of the defendant's argument, which I'll address in a moment, hopefully, on the Bowden instruction, that the police failed to go to the McDonald's, failed to investigate whether or not he was there eating breakfast, look at a videotape if he was there, because had he been there, he couldn't obviously have been at the scene committing the crime. Even though
it was only
he
7
was
minutes
8
away.
to 10 minutes away.
Basically, was there any evidence that there indeed was a videotape of the McDonald's has a videotape?
We don't know, and that was part of the defendant's at the retrial. That was part of his argument. We don't know what was in place back in 2000. He was just arguing that there was a failure to gather that evidence. So we don't know that fact. But I would point out that that same evidence was present in the first trial. All of this evidence was present in the first trial. The court still said it was significant or sufficient because of the motive evidence, because this other evidence is weakly circumstantial in the court's terms.
May I just, for clarification, wasn't there also a witness who said that she saw him in the apartment building coming down the stairs?
I'm coming to that, yes, Your Honor. There was. That's Ms. Guzman, the daughter of the owner of the building. At the first trial, she did not testify to that. The grand jury, she did not testify to that. In her voir dire, in this case, she did not testify to that. She did testify to that. She notified the Commonwealth 2 days before trial that she had seen that. Now, as I said, the evidence of the first trial was the same except for her testimony. Now, her testimony was confused, inconsistent, contradictory, and probably untruthful. In closing argument, the prosecutor backed away from it and said to the jury, I don't blame you if you don't believe a thing she said. I don't think her testimony can be figured in the calculus of whether there was a miscarriage of justice or not. It's the same evidence, apart from that was at the first trial. And I would note that the motion for a new trial was granted by this court for the erroneous admission of precisely this same evidence. That is, she went out for the divorce and the boyfriend moving in. Precisely that evidence is why this court granted a new trial.
But you're agreeing, I think, that the evidence itself, the answer was okay. It's just what the predicate of it was.
If it was an answer to other things in this excited discussion, that's one thing. If it's an answer to a question saying, why did he do this? What was his motive for acting? That's objectionable. That gives to the jury an inference that they may or may not have drawn. That's their province. We can't speculate as to whether they would have drawn that inference. The problem is it came in as evidence of motive. And not just evidence of motive, but a witness saying this was his motive. That's for the jury to draw. The Commonwealth says, well, this was a permissible inference for the witness to draw. I suggest that that's just wrong. Juries draw inferences. Witnesses don't and can't draw inferences. And the problem here is, however this evidence may have come in some other case or in some other way in answer to some other question. It didn't come in that way. It came in as an answer as to why this individual did the act that he was accused of doing, that is, trying to run her over the car. Coming in that way, in this case, in response to that question, it was erroneous. And it's precisely the same evidence that this court held in the motion for a new trial was sufficient to create, error and prejudice. And this court granted a new trial because of that.
But you're not saying that had the proper question been asked, that answer could have been given.
Yes, he is saying that.
I think he is.
I think if she
If she had said, what did you say to him that caused him to do this?
that would have been objectionable.
Why?
Because it's the same question. What caused him to do this? Why did he do this? What did you say to him that made him do this? All asking the same question, Your Honor. What was his motive?
Okay, so did he do this in response to something that you said?
I think that's objectionable. The same reason. It's getting into a state of mind. And you can't give an opinion on his state of mind. If you have a conversation where the mother just blurted this
I told him that I was moving in with my boyfriend, and what did he do? He exploded and he threatened to kill me. That's not admissible?
I just say that was not admissible. That may have been, had it been put in a different way. If she had said, look, I went out with him tonight to tell him that I'm filing for a divorce and my boyfriend's moving in. And the daughter said, well, what did he do? If she then said, he tried to run me over with a car, that's arguable. But that's probably within discretion.
And then the
of judge.
prosecutor can argue that was the motive.
The prosecutor can argue that because in closing argument, it's appropriate for counsel to draw those inferences and say the jury can draw those inferences. It's not permissible for a witness to draw that inference and say, this is why he did it.
Okay, so if there had been an objection, a proper question could have been put to the witness and the same information could have come in.
Most likely.
Did the prosecutor here argue? You heard the testimony. She told you that it was because she had said that she was getting a divorce and her boyfriend was.
I think that would have been an objectionable question.
My question is, you had this, and I agree with you, objectionable question. You have an answer that I think none of us is disagreeing, including you, could have come in with a proper question.
Right.
Okay. At closing argument, did the prosecutor in this case argue it in terms of this is what the victim said was his motive,
I think that's correct.
or just this is the motive?
This is.
You can infer this motive from this
I think
information.
they basically referred to that answer as why he ran her over the car, because the motive evidence of the divorce was what they were using as the evidence of motive for the murder.
Understood.
But you could, as you said just a little while ago, they could have argued that if it had come in through a proper question, you would not be challenging the ability of the prosecutor to argue in closing, this is the motive.
That's correct. Prosecutor can draw those inferences or ask the jury to draw the inference. The problem here is you have a witness telling the jury, this is why I act. But I make the point that in this court's granting of the motion for new trial is precisely the same evidence. Now, in that case, there was a difference between the way the witness in voir dire talked about the conversation. And then when she got on the witness stand, she said, this is what she heard her mother saying to the police officer. And this court said, can't come in that way because that's testimonial. So it's precisely the same situation. It could have come in that trial, this court said, had the daughter testified to it as she originally said she could. But because she testified to it as overhearing it from the conversation between the mother and the police officer, that's objectionable. Even though in that case, as here, the prosecutor could argue that the jury could draw an inference that's the motive. It's still the method in which it comes in
But in
which
that,
governs its admissibility and the harmfulness.
that wasn't pursuant to an excited utterance, that overhearing the statement made to the police officer, correct?
That's correct. That was held to be
Just plain
testimonial and
Hearsay
conclusive.
issue.
No,
No,
Problem
just
is that
cross-examination.
she had
No,
originally
testimony.
said that her mother told her that. And at trial, she changed it and said,
I
I heard her
understand.
tell it to the police.
Thank you.
So again, it's the different way it comes in. It would have been admissible, this court said, had it come in as she originally said, but it came in the wrong way. That's what makes the difference. We can't speculate as to what could have happened. The rules of evidence are there for a reason. I think we're bound to follow them and to apply them and to say it comes in as motive. That's objectionable, and it does create a substantial risk of a miscarriage of justice because that is the crucial evidence, as the court held both in the first trial and in the motion for a new trial. We suggest here we're dealing with exactly the same evidence, and we say it came in wrong. I think that's clear. It did create a substantial risk of a miscarriage of justice. How it would have come in with a different question, I don't know, and neither does anyone else. Would she have said it in precisely the same way, with the same emphasis, or not? We don't know. We do know how it came in here. We do know what she said, and we do know it was objectionable. It was error for it to come in. We do think it created a substantial risk of a miscarriage of justice.
Or likelihood. Substantial likelihood.
A likelihood. I'm sorry,
Yeah,
Your Honor.
that's all right.
Thank you for correcting me, because, yes, that is a better standard. The second issue I want to address briefly is the refusal to give the instruction based on Commonwealth v. Bowden. An important part of the Commonwealth's case, of the defendant's case, both in his questioning of the police and in his closing argument, was that the police failed to conduct certain tests and gather or investigate certain evidence, particularly failure to conduct DNA tests on hair and blood found on the victim's bed, failure to do a chemical analysis of the boyfriend's clothes, failure to seize the caller ID from the victim's apartment, and failure to go to the McDonald's to see if there was anybody remembered seeing him there or whether there was a videotape. The defendant requested the instruction, as we set out in the appendix. The judge said he thought the police did a lot and found nothing. And so he concluded, quote, "But I can't say that they didn't do anything, so I'm not going to give the instruction." It raises three issues. The first, the court misapplied Bowden. Bowden does not say the test is whether the court did nothing. It said whether they failed to conduct, in the court's terms, certain tests or produce certain evidence. The facts here supported the Bowden instruction. It's for the jury to draw the inference of whether that indicated a faulty police investigation. That's not the judge's determination.
But you wouldn't disagree, I'm sure, that whether or not to give a Bowden instruction as opposed to allowing the Bowden evidence to come in is a highly discretionary matter for the judge. So if the judge had just said, "I'm not going to give it," period, there wouldn't be any argument, would there?
Yes, because that's the argument we're making.
I know it's what you're making, but...
Yes, we're
and what
saying
would-
that the failure to give an instruction, this instruction, violate the defendant's Sixth Amendment right to present a complete defense. A defendant has the right to be instructed, for the jury to be instructed on his theory of the case.
Yeah, but he doesn't have a right to have the judge put his thumb on the scale. And isn't that why most judges don't do it, don't give a Bowden instruction?
I don't know why most judges don't give a Bowden instruction, Your Honor, but it doesn't put the weight on the scale. As this court said in Bowden, this is a failure of the police to produce certain evidence or conduct certain tests is a proper basis from which to build a defense. The
But
defendant has
he argued it.
There's two different things: the right to argue something and the right to have the court give the controlling law on the issue and tell the jury that they can draw this inference if they so find it. For example, in United States v. Noon, the issue was the complaint that the judge didn't instruct on flight, on what inferences you can draw from flight. That's not an element of the crime, and clearly the defendant could argue it and did argue it there. He didn't win in that case because the judge, in fact, instructed on flight, but in different terms. So, yes, you can argue it, but to have the jury instructed on your theory of defense, and the law recognizes that this is a proper inference from you to draw, is your theory of the case, and you have a right to have the jury instructed on that.
Mr. Graham, I'm sorry, your time is up.
Oh, thought I had 38 seconds. Sorry, Your Honor.
Thank you.
Thank you.
Good morning, Your Honors. Paul Lynn for the Commonwealth. With me is Mark Lee, the Assistant District Attorney who tried the case. May it please the Court.
Second time. The second time.
The second time, yes. Regarding Yesenia Lau's recounting of the victim's spontaneous utterances, this is a classic case where an objection was needed to bring this issue to the judge's attention. It came in basically as the victim had stated it, as a prosecutor generally should, asking, what did she say? And then he did, yes, ask, did she say what caused it? The Commonwealth argues that there is no case law saying that's absolutely impermissible regarding a spontaneous utterance, because you're not commenting about a witness on the stand. You're just recounting what the victim said. But regardless, even assuming it was an improper question, which the Commonwealth doesn't concede, this isn't the same situation that this court faced in the first, well, actually, I'll call it the previous Lau appeal. There have been 3, but the one in which this court granted a new trial. There, as my brother pointed out, although Yesenia testified on voir dire that the victim had told her the entire story immediately, including the fact that she had told the defendant about her intent to divorce him and her intent to have her boyfriend move in the next day, she didn't repeat that at trial. And although the Commonwealth argued, well, that was just because it was pre-Crawford, the court nonetheless said that evidence wasn't there. It simply wasn't there. And we don't know whether that's because it just wasn't asked or whether she was changing her story. The only evidence that was before the jury about this motive, about the fact that the victim told the defendant that she was divorcing him, came in through the conversations to the police officer that the victim made later that night. So there was no evidence of motive in that case besides the improper evidence. Here, the evidence is proper. There's no question that the victim's statement to her daughter in the bedroom was admissible as a spontaneous utterance and was not testimonial under Crawford. So in this case, it's simply a matter of the form of how the evidence came in. And under those circumstances where there was no objection, and where an objection would have completely cured the error, because, as you said, the prosecutor would simply have had to have rephrased the question, there is no substantial likelihood of a miscarriage of justice.
Did the prosecutor, how did the prosecutor treat this in the closing argument?
I was just looking through my notes on that. My recollection is that he treated all of this evidence very broadly. I don't think he quoted and said, you heard Yesenia say what the victim said. It was simply a matter of saying, this is a case of a crime of passion, a crime where the defendant literally choked the life out of his wife, and you heard her children testify about the relationship and what the victim said. So I don't think there was anything that specific to the form of the question. He didn't say that, for example, you heard Yesenia testify that the cause of the accident or the cause of the attempted assault was because she had told him of the divorce. I will turn also to the, are there further questions on that issue? Thank you. I would turn also to the so-called Bowdoin instruction. Needless to say, this court has decided as recently as 2 years ago in Avila that there really is no such thing as a Bowdoin instruction. The actual Bowdoin instruction was the incorrect instruction that the judge gave in Bowdoin, that the jury could not consider evidence of police omissions. Here, there was no...
Well, there is a Bowdoin instruction.
True,
since
true.
I gave it when I was the
right, yes,
court judge at
it
the time,
has
so
become
it exists.
it has become known as the Bowdoin instruction, and I will not be glib about that. But this court has emphatically said that the only thing that Bowden requires is that the judge allow the defendant to raise the defense. And here there's no question that the defendant was allowed to cross-examine the police officers about their omissions and the other witnesses who were relevant. For example, Yesenia about the caller ID box, the officers that they didn't go to the McDonald's and check whether there was videotape, the fact that the police officers failed to test the clothing of Ramon Rodriguez, the boyfriend. And he was absolutely able and indeed argued emphatically that cast doubt on the professionalism of the police and the proof against the defendant in his closing argument. So there's absolutely no requirement under the circumstances. This court in Dean just several months ago recognized the federal standard, quoted the federal standard on which the defendant relies, and still held that you don't need to give an instruction regarding a factual defense. Clearly, if there's something legal, like self-defense, something along those lines, reasonable provocation, that has to be explained to the jury in order for them to understand it as a legal concept, there's no question that there's a need for an instruction. But the judge isn't required to instruct about every factual defense. He gives the most general instructions regarding credibility of witnesses. He doesn't have to talk about every single facet of credibility. And he certainly doesn't have to say that you may consider the specific fact that there were omissions by the police. I would like to know also if this court has any questions about the other issues. I do have a few things I would like to say about them.
Well, I was wondering if you could address, I don't have a specific question, but I'm just sort of, it's mushy in my mind about the timeline.
It's a mushy timeline. Yeah, the basis of the timeline, as the prosecutor pointed out, is there are 3 fixed points. The first fixed point is 8:50 in the morning, and that is when we have a receipt, a timed receipt from Home Depot and video footage of the defendant buying the door at the South Bay Home Depot. The second is at 10:35 in Waltham.
It's 10:14 is the second one.
You're right. 10:14 comes first. I was going around. 10:14 is the second one. Absolutely, is the dispatch time that the police are dispatched to the crime scene in response to Mr. Rodriguez's 911 call. And the third one, thank you very much, Justice Gantz, is 10:35, which is when Mr. Bolus, the postal supervisor, is taking these unbelievably detailed notes of Mr. King's postal route. And he says at 10:35, that's when they start delivering mail. That's when King starts delivering mail on Linda Street in Waltham.
And he says it takes 5 minutes.
Takes 5 minutes. That takes you to 10:40. They don't see a white van. They don't hear any construction noise. Defense argues, well, we don't know. Maybe he was in the back. Maybe, who knows? They couldn't see everything. They didn't take note of every vehicle. But at 10:35, there's no construction noise. And as I point out in my argument, that's a very conservative argument as to when the defendant was arrived on Linda Street, because there's actually nobody who hears him or sees him on Linda Street until at least 10:50. That's Valverde, the defense witness's first estimate, earliest estimate of when he arrived. And she's very equivocal about that. She says it was between, it was around 11 o'clock, maybe as early as 10:50. Another time she says it was while I was watching a program that comes on at 11. So again, even that is a very rough time period. The defendant, as we argue in our brief, certainly could have arrived on Linda Street pretty much as late as he could have stayed on Bellingham Street, because obviously if he stays there after 10, he's going to run into Rodriguez as Rodriguez is coming back. So those are the three points. Other points that are important are the defendant admits that he goes to the McDonald's in East Boston and he arrives there around 9:15. Also, Trooper O'Leary testifies based on his living in the Boston area and working as a trooper in the Boston area, and he gives 3 routes, if I remember correctly, that it would take about 15 minutes to get from the South Bay Home Depot to the McDonald's in East Boston on a weekday. So you definitely get the defendant, by his own admission, at that McDonald's around 9:15. He says he talks to the victim for about 2 minutes. That takes you to 9:17. And then again, O'Leary says it would take about 7 minutes with the lights to get to Bellingham Street. So that's the basis of the prosecutor's argument that the earliest the defendant could have got there was 9:24 a.m. And the latest, obviously Guzman doesn't see, this is Francisco Guzman, the father, not Millie Guzman, the daughter, never sees the defendant, but he's important because he sees Santiago. And Santiago is the one who sees the defendant as he's walking up the driveway to get to the back of the building. The defendant is walking back out. So, and he says that's about 20 to 25 minutes before the police arrive. I would point out there was no dispute at trial that the police, about the arrival time of the police. The defense knew that the police had arrived within minutes. It was never disputed. So the argument the defendant makes about, this 10:14 was the dispatch time, the reason there's never any objection to when the prosecutor occasionally in his closing argument says the police arrival time was 10:14 is it was undisputed. They were in the same small district of Chelsea. They all got the same call. They all arrived simultaneously. That's the testimony at trial. So it's still the prosecutor's argument that 20 to 25 minutes before that was before 10 o'clock was eminently reasonable.
Okay, thank you.
So the important part was that the defendant could have been at the scene any time between 9:24 and the prosecutor said 9:52. In our brief, we argue it was really closer to 10 o'clock. So he had roughly a half an hour to commit the murder and still be in Waltham by the time Valverde heard him. I would like to talk about Millie Guzman just briefly. Just to point out, first of all, that the defendant's main argument is that her testimony establishes the possibility of a discovery violation. The record leaves no reasonable possibility that that's actually what happened in this case. She immediately retreated from that. Across examination, she said repeatedly, I really don't remember what I said to the police 10 years ago. And there's simply no logical way that this evidence could have been withheld for 9 years. This was evidence, according to Millie Guzman, that she saw the defendant coming down the back stairways of 122 Bellingham Street on the day of the murder after hearing dragging noises and screaming. And yet, that's never put down in a police report. She doesn't testify to the grand jury. She doesn't testify to it in the first trial. And the police obviously have no conceivable motive to withhold this evidence. It's inculpatory evidence. So the only inference you can draw from that is that she was either mistaken or she actually perjured herself. And the prosecutor, under the circumstances, did everything he could to point out that she had not made the statement prior to 3 days before the trial. There were occasional references to a proceeding in 2002, but I cite Qualls and Jackson for the case that occasional references to a prior trial are generally not prejudicial.
Now there was a motion for a mistrial as a result of her testimony, which was denied.
Denied, yes.
Am I correct that we don't know the basis for the judge's denial?
It just says denied. I think there's discussion. The defendant makes the arguments that he can't cross-examine her without going into the first trial. He also just says this is completely unbelievable. This is incredible evidence. You've got to get rid of it. And the judge says no. That's grounds for cross-examination, not grounds for a mistrial. I point out he doesn't really raise continuance, but this was still consistent with his defense. His defense was anybody who saw him at the scene must have been mistaken because he was in Waltham. That was always his defense. It was his defense in his opening statement, his defense at the end, his defense throughout the trial. And third, he was able to cross-examine Millie Guzman extensively, first of all, to make her back off from the statement that she had told the police originally. He points out that she can't remember the time, but he does get her to admit that she thought it was well before 10 o'clock. She said it couldn't have been as late as 10, which hurt the Commonwealth case. He points out that her father, Mr. Guzman, was in the house when she first heard it, and that he came in shortly thereafter, and she didn't tell him that she had heard the screaming or seen the defendant coming down the back hallway. And then, of course, in closing argument, he compares her to the Tooth Fairy and the Easter Bunny. And Mr. Lee says, this is obviously not an ideal witness. You can throw out her testimony if you want, but she did say she saw the defendant. I think under those circumstances, the judge's denial of a mistrial and a continuance was well within his discretion. Are there any further questions from the court? Thank you very much, Your Honors.
Thank you, sir.